All right, welcome everybody to
Shannon's back.
the Friday, April 20th, 2018 equalization hearings. We'll reconvene. I'll recognize Shannon.
Good morning. I want to start out with something unusual this morning. I want to introduce Jean and Randy that are sitting to my right at the back of the room. They are with our CAMA system. They develop the software that we use to appraise property in the county. It's a software that's used by many jurisdictions across the country, and they are here working with another county, but stopped in because this is so exciting that they wanted to see this before they flew back to Texas where they're from.
Okay, well, welcome. Enjoy Rapid City, South Dakota and Pennington County.
Okay, so the first thing on the schedule is some park models. And we've talked park models for the last couple of years. The first two lines on that schedule are Tim and April Nugtren, Brendan Dan Pettit, Wanda Weinrich, and Castle Creek Enterprises. Those are all the same issue with park model homes. The property owners are here. I would suggest you let them speak. I'd like to make some comments in advance of that, though. As all of you know, we are currently going to court over these properties for the 2017 assessment. Court is 2 or 3 weeks. I met with Jay and the attorney for these property owners yesterday. We were all morning talking, preparing for court. And I would like to suggest that you don't make any change to the assessment, but I want to tell you that these property owners have the right to file an appeal or a notice. I'm not sure the legal term with circuit court. If any property owner here is unhappy with the decision, they can appeal on to the Office of Hearing Examiners and then to circuit court, or they can appeal from here to circuit court. And if that is done in this case to circuit court, there is no reason to expect that if the county were to lose the case for 2017, that all of the facts are exactly the same for 2018, and the court would rule that it applies to 2018 as well. That's common sense, and there'll be no argument from the county because they are the same property. So, we do have. I'd like to suggest that you let the property owner speak if they'd like, but we do have a recommendation to change one of them. There's a shed on one of these properties that doesn't have any value, but maybe let the property owner speak, and then we'll deal with that.
Okay, thank you, Shannon. First up is Tim and April.
Morning.
Did Shannon do a good job of explaining what's going on?
Yeah, I think so.
Okay.
I think so. So I won't bore you with all the details. I mean, this is the third year we've been doing this.
Yeah.
The only thing I had a concern about was on our property record cards. On the first year, back when we first appealed and we won that appeal, we were listed as a primary single-family resident, and our description was a park model. And the assessed value at that time was $30,200. And we appealed at that time, won that appeal. The next year, we were listed as a commercial property. The building type is a motel with a guest cottage listing, and our assessment went up over 30% to $39,400. And I brought that up last year, and I never did get a good answer, just it was some inner detail that they marked down. But now for 18 again, we're still listed as a commercial property with that assessment and with the motel and the guest cottage. And I'm just wondering how we can be a commercial property, because we are not renting out our cabins. We don't receive any funds from these. It's just a camper.
Okay.
And I'm just concerned why the increase was so much and why it's a commercial property.
Okay, Tim, I'll ask Shannon if he can explain.
Yeah, I can explain that. In our mass appraisal process, we consider all three approaches to value: the cost approach, sales comparison approach, and the income approach. And we don't do an income approach on these properties. That wouldn't be applicable. But we do a cost approach, which is replacement cost new less depreciation plus the land, although there's no land value in these. But we have to identify what type of building it is. And in our CAMA system, there's no building description for a park model, but there are other building descriptions that describe a park model to a good enough similarity that we use that for an estimate of replacement cost. And both of those do that. The guest cabin or a single family residence. Single family residence is not so good because the cost to build a house is different than these. So we've played with it to try to find the right number to do an appropriate cost approach, and then we still use the sales comparison approach, and we check our cost approach value with sales. And the value we have on these is actually well under what was paid initially and what we have sales for. The commercial note there, that's just in our appraisal process, has nothing to do with the levy. It's
Well, it went up $9,000.
and that is market value, yeah, but it's still, that doesn't have to do with that word commercial there.
But we're a camper. We should be depreciating, not increasing in value.
We don't see that in the market. They're new enough. Buildings do depreciate, but we do have sales of these, and they still sell for more than we have them assessed.
Right. And yeah, we have no intention of staying at Horse Creek for the economic life of this thing, and who is to say how long that is, I'm retiring in 5 years from the fire department in Sioux Falls, and at that time, we're looking at property now. We're gonna continue to look for property, and we're gonna either buy a place or move this thing to somewhere else, or that's our plan. So there's no intent to stay here for the term of this trailer. So, I guess that's all I got. So I won't rehash what we all already know.
Okay, thanks, Tim.
Yeah.
Should we do the other ones, Wanda and them too? Or do you want to?
Next on that same line is Dan and Brenda
Oh,
Pettit.
Dan and Brenda, yes.
Good morning.
Morning.
We too are here to appeal the assessment on our park model camper. We are looking at the fact that we purchased this park model camper in July of 2015, at which time, under South Dakota State Law 32-3-1, our camper is described as a recreational vehicle. We had to pay tax and title to the state. We also had to pay a registration and license at that time, and that was effective through August 31 of 2016. Simultaneously, at the very same time, we've been expected to pay property tax for the same camper. So we have paid tax twice on the same thing to the state, to Pennington County, the state, and don't see that that's appropriate in any way, shape, or form to be taxed twice on the same camper. We look at our camper in the fact that it can move, it's ready to move, it's on its wheels, the wheels are there, the brakes are there. It has detachable lights. We put it on, we attach the tongue, we move it. It's movable. It's not permanently affixed to our campsite. We don't have a lease at our campsite. We have a campsite agreement that states we have no obligation to stay there. But probably more importantly, the campground owner has no obligation to let us leave our camper there longer than till the end of the month that we've paid our rent. So he could come in on the 30th, when the end of the month is the 31st, and say, you gotta be out in 2 days, and we have to pull our camper out and leave. That's really important because, guessing you probably already know, the campground is currently for sale. So we have no idea what the new owners may do. We could all, once it sells, if that owner decides he doesn't want to maintain the campground, our campers have to go, and they will go. So that's a really important piece to us. As far as the intention, we understand that there's a concept of, if we take the wheels off and we set our camper down and we permanently affix it to our property, that we've made it no longer a camper. And we would probably have to pay property tax. We don't disagree with that, but that's not what we have done. We have not done any of that. We have been working with a realtor for 3 years to find the right piece of property out here in the hills. Haven't come up with the right piece of property yet, but our intent is to pull this out. This is a segue, somewhere for us to stay without having to pay motels once a month while we're looking for property. And at that point, we'll move it to the property. But that's our full intent. Our intent, we know that it's been brought up that you know, it's not about that the intent of to leave it there for the economic life of the camper. Well, I'm not going to be alive when the economic life of our camper runs out. You know, Gulf Streams go 50 years. So the concept that we intend to leave it there at this campground that's up for sale for as long as it's going to be, that doesn't apply to us. We have no intent to leave it there. The next thing we have is we too are assessed as commercial motel guest house. Initially on the first assessment, when we finally did get a card, we never got the assessment because they couldn't read our license plate or couldn't read the sign on our camper that said the Pettits. So we never got it, but we had to pay the tax because we didn't get to appeal because we didn't get an assessment. Once we finally got a property tax, it was listed as a single-family residence, as are at least 4 or 5 park models at Blue Wing and around the county are listed single-family residence. Park model is the descriptor. So, and you know, I have the research on that if you need it. And that's kind of where we're at. We don't feel that a property tax is appropriate, especially not for the time period that we had to pay 2 taxes. And if you do feel that property tax is appropriate, we're certainly in no commercial. I just can't fathom how we would be expected to fall under commercial motel guest cottage. I can't imagine what kind of other repercussions that would have on us to be listed on your property rolls as commercial when we're not. There's nothing about it. This is our guest home. We're there this weekend. We stopped in for 20 minutes in December to check things. We have not stayed there since October 4th of last year. We're certainly not using it in any other way than our camper.
Thank you, Brenda.
Thank
and
you.
I'll just reiterate, well, I'll let Mr. Buskard.
The first half of hers, that's what's in court right now. So,
The 2017 assessment is in court.
well, I think it's inappropriate for us to make decisions on that since that's the case that's in court. I mean, not this particular one, but the same thing. And however that's decided is what's going to happen this year.
Yes, there's no reason to expect that whatever decision we get from the court shouldn't apply to this year. The facts are the same.
Well,
You
and
got-
I just want to make one comment that we did send a letter to the legislatures to form a task force to come up with some ideas on this, and it was not reviewed or accepted to have them work on it. We did send that this year, just to give you folks some idea that we just didn't take any action. We did as a commission in the counties.
The perspective of the legislature is the law is good enough. It's been to the Supreme Court, so it must be good enough. And that's what I get when I try to work with legislators on this.
So the bottom line, can we wait to see what that comes out and then,
Your Board of Equalization is going to adjourn today. So for the 2018 assessment, you need to make a decision on it. And that's why I suggested that you go with a no change in value, because we're in court arguing over this. If the county loses, though, let's say the court rules, because this is what the appellants are asking, that the property should not be taxed. Okay, there's no reason to say that they shouldn't be taxed for 2018 as well. And the judge will rule that way, and Jay and I are not going to argue otherwise.
that
So
makes
as long as they file an appeal with circuit court for 2018, so the judge can consider 2018, and their attorney is aware of that, and he's planning on doing that.
So that makes sense to not have no change and then let it go to court, and if it changes, well, then it changes and it goes back to,
Then the judge rules that way, absolutely.
yes, that's where I'm going.
Yep.
So Shannon, are you done?
Yes, sir.
Mr. DeSanto?
The only question I have is, she's got a note in here about a shed, and that
Yep.
the shed's smaller than it was
140 square feet.
reported, and that it doesn't qualify for being assessed. Is it part of this assessment?
Yes.
Yes, and that's what I said, I have a recommendation to take that off.
Okay.
I suggest maybe let the other two property owners speak, and then you act on all of them, and Don will step up with that dollar amount on that shed, and we'll deal with that.
Okay. Thanks, Brenda.
Thank you. And then I guess I would like to just kind of say, the state Supreme Court, actually, they have spoken on a situation of park models, but the only thing the same between Rushmore Shadows and us is that it's a park model RV. We don't meet any of the other criteria that those decisions were made on, just so you're aware. And then that decision also stated statutes that impose taxes are to be construed liberally in favor of the taxpayer and strictly against the taxing body. And we don't meet any of the things. Quite frankly, we agreed with Rushmore Shadows when they were using them for their own commercial purpose, but
Yeah.
Mark has no value. He can't use our camper as a guest cottage.
Yeah.
And we can't either. We don't have licensing or hotel
Yeah,
licensing.
Brenda,
Thanks,
we went through
sorry.
this all last year.
Yeah, my,
Yep,
How
so,
about-
but, yeah, thank
Yeah.
you.
my
But
bottom
thanks.
line is that,
Yeah.
it's gonna be decided this year. And one way or another, either you're gonna get taxed or you're not gonna get taxed. And then we can move forward from there. Because I think this year, for me, I'm probably gonna leave it to the same except for the shed and then see where that goes. And then we'll know what to do in the future to make sure everybody's on the same page.
Okay,
Does that make sense?
yeah, as long as we're taxed correctly, if that's the decision, that's all we ask, is
Okay.
that it be
Okay,
correct.
thanks, Brenda.
Thank
Mr. DeSanto has a comment.
Shannon, in all of these cases, or the two cases we're looking at right now, did both of these families have to pay vehicle registration fees on both of these park
The law
models?
requires that when you transfer title, the treasurer's office, when you buy one of these things, you get title in your name, you take it to the treasurer's office and you get title in your name. The law requires the treasurer to collect 1 year's registration upon transfer of title.
Okay.
Now, that is the same thing with a car.
Okay.
But the same thing with a car, if you never drive it on a public road, you never have to again.
Right.
I'll reiterate, even my camper, it doesn't leave where it's at. I did the same thing, paid it, but if it's not going on the road,
Yep.
I don't register
tax
it
as
every
well.
year and pay the tax.
Gotcha. Very good.
Until they decide to move, then they gotta come get,
Absolutely.
okay. Thanks, Brenda.
Let me address the commercial thing. Again, I want to be a little bit more clear. There's no commercial tax in South Dakota. There's owner-occupied, not owner-occupied, and ag. And there is no commercial, owner-occupied or non. The commercial is a note in our system and the way we arrive at a value, and specifically how we estimate the cost to build something. And we initially used a single-family residence because we're calling these things homes. But when you imagine all of the cost that goes into a home, from the roof all the way down to the foundation and all of the utilities, that's more money than what it would cost to build one of these park models, because you don't have all of that stuff. We found in our CAMA system the identifier for a guest cottage. It happens to be called a commercial structure in our CAMA system, but doesn't matter. A guest cottage is a much smaller, minimal home that fits a description of what a park model is. And all it is for is to estimate the replacement cost and go through that cost approach to value. Has nothing to do with the tax. And in the end, we're still looking for market value anyways.
Okay. Thank you, Shannon.
Thank you.
Thank you, Brenda. Next, we have Wanda. I wasn't going to try to do it.
That's all right.
So just,
Forgive you.
just please identify yourself.
My name is Wanda Weinrich. My permanent residence is in Colorado. I bought this park model home in September of 2015. Kind of a little bit of a history. My husband and I used to live up here. As a matter of fact, I used to work with her at Conseco. We love the area, but my husband had to change jobs because the economy up here, as you know, it's not very good. So we moved to Colorado. Still, we had a camper. We came up here, camped up here, loved it. In October of 2014, my husband passed away. I still love the area. I still want to come up here and camp. But for me to have a truck that can pull a camper, pull it up here, and I can back up a truck, but backing up a truck and a trailer is a little difficult every now and then. So I sold my camper, but I still wanted to come up to the area. So I got on the website and I thought, okay, I'm going to look for a property up here. I can't find a property up here that was within a price range for one person. Because I live in Colorado, I would have to hire somebody to take care of all the property, look it over, watch it, and everything like that. So I came across these park model homes and I thought, perfect. My husband and I thought about, we would go ahead and retire up here. So I thought, well, I'm going to make my first step. I'm going to sell my camper. I'm going to buy one of these up here. It's on wheels. It's got the tongue on it. I can pull it out. I can pull it off the, it's not, pardon me?
Pad.
Correct, yes. There is no, there's no foundation. So that was my plan. I was going to go ahead and buy that, pay that off, look for a piece of property in the interim. Then when I found a piece of property, move my trailer, my camper onto that property and put it there, set up sewer, whatever I needed, until I could afford to buy a house when I retired. As a matter of fact, I started that process in September, well, actually last summer. I had contacted Carl Larson Construction. He's a friend of mine. He was going to help me find a piece of property, talk to Jim Peterson with Peterson Realty. Also visited with Kelly Howie team from RE/MAX, looked at properties. I was going to take my camper, put it on that property, and temporarily put in the sewer, the electricity, everything that I needed, and then eventually build the house. In October 1st of 2017, I got shot in Vegas. So, all those plans have now been put on hold. They have not been completely been disregarded. They are not, it's going to happen. It's just right now I'm in therapy, physical and emotional therapy. And as soon as I get through that, I will be coming up here, and I will be moving that trailer onto my own piece of property. And I will be living there in that trailer on the property permanently. But until that time, it's not permanent. There is no foundation. The wheels are under it. It's just convenient to have it in one spot where I can come up and visit, and I don't have extra maintenance for a vehicle to pull a trailer that I can't back up. And I don't want to be disrespectful here, but you had mentioned something, your camper sits somewhere. So where does your camper sit?
Heart Ranch.
Okay, so do you pay property tax,
I pay storage.
storage? Okay, but it's sitting on a pad, on a lot, right?
It goes from storage to comes out.
To what?
It goes to storage, and then you pay maintenance. Similar to what some of these parks are doing, they charge you so much to have it. It doesn't stay in one spot permanently. You have to rotate every 21 days if you go to use it,
Yeah.
that type of thing, so.
Well, there's not enough spots for us to rotate out there. And as Brenda has stated, the property's up for sale. It may sell tomorrow. I may have to take it, pull it off the lot. I don't know. But it's not permanent. My contract or the rent that I pay there, just like you pay, the rent that I pay is month to month.
Well, thank you, Wanda. First of all, I want to say thank you for your perseverance and what you've gone through and so forth. And I just want to thank you. I know it was hard. But as you've heard, we've had, this is in litigation and we'll work through that.
I understand that, and I don't have a problem paying for property tax as long it's on a piece of property that I own, that I can enhance, that I can build upon. This property I can't. If I put a tree down, I can pull the tree out, but that, it's not permanent.
Yeah.
I can move it, and then somebody else can move in my place.
I don't want to start going back and
Right,
forth.
I understand that,
But-
and, I appreciate your time in listening to all this. I just want to make sure that you understand what our position is. It was put there as a stepping stone to the next step. It's not permanent. I don't want to live in a park when I retire.
Yeah.
I want to live up in the hills. I want to live in the trees. I want to have my own place. Right now, it's a little difficult being around people. So, but anyway, that's pretty much my story.
Thank you,
I just
Wanda.
hope that you rule in favor of the park models and.
It sounds like it's going to be coming soon, so at least we'll all have a clear direction to be able to go by.
Okay.
Mr. Chairman,
Mr. Busby.
sorry to hear about your troubles. I have to disagree with one thing where you said the economy of Rapid City is no good. It actually is pretty healthy right now.
Well, we moved.
We don't have marijuana
You know
to
what?
build up our economy like Colorado does, but we also don't have the problems.
Right, and you know what? That's why I want to move back to Rapid, because of the legalized marijuana and all the influx of people. I love it up here, I really do. The economy was kind of poor. My husband drove truck, and he got a job down in Colorado working for the oil field, so he was able to stay home.
Thank you.
So, any other questions?
No, thank you, ma'am.
Thank you, Wanda.
Yep.
Castle Creek.
Yeah, let me tell you what it is. Pull up a picture, Chris. I also wanted to add, though, that everything that was said by the property owners will be introduced in testimony in court. I spent 4 hours with 2 attorneys yesterday, and all of that we had discussed, and that plans to be entered as affidavits, or if we have to have a live court, it'll be testimony. We discussed all of that, so I'm aware of it. Jay's aware of it. Their attorney is planning on it.
When is that again, Shannon?
It's in May. I said 2 or 3 weeks.
Okay.
We are working towards, I will give you a heads up as what the attorneys are planning, is if both attorneys, both sides can agree on a set of facts, that they can introduce that to the judge as stipulated facts, and we all agree on these facts, and then we're going to argue the legality, the issue of the law. If can't agree on the facts, then it has to be testimony and a trial, and much more expensive and time consuming. So the hope is that we can get some stipulated facts and then the two attorneys write briefs and argue by pen instead of in person. And it looks like we're going to be able to do that. And it'll be cheaper and quicker.
Okay, thank you.
Okay, so this is Castle Creek Enterprises. This, same thing as all the others. The park model, every much the same as the others. Last year, this set on the driveway, the parking lot up by the office.
Oh, yeah.
And the commission took this off the tax roll saying that it was in dealer inventory. I don't, and I said this at the time, I don't think that matters, okay? It has now since moved down and it is set amongst all of the others. And it looks every bit the same as all the others. When it's set up top, okay, we could say it wasn't hooked up to utilities, it wasn't the same. But it is now. So it's on the tax roll, and I think we've got Mark Rutherford on phone. He said he couldn't be here. He wanted to call in, and I think Paula's got him on the phone.
Joan, do you got him on the phone? Oh, good. Mark, are you there?
Mark, are you there?
Yes.
Joan, a little bit louder.
Can you hear me?
Yeah, you have to speak close to your phone, Mark.
Okay.
Joan, maybe a little bit louder. No, okay, that's it, Mark. You're a little low. You'll have to speak up, and the board is listening to you.
Mark?
Okay, so who starts?
Well, Mark, we'll let you talk. We just took testimony from about 3 others on the park models, and we rehashed kind of the same stuff that we had last year, just to give you a little background. So Shannon had shared that I'll let Shannon speak on that.
Mark, maybe I should say what I said to the commission. We are in court, as you know, over the 2017 assessment. I met with State's Attorney and Courtney Claiborne yesterday, and it was discussed that if the property owners of the park models appeal the decision, if the board here doesn't change the value, if the property owners appeal to circuit court, that preserves the right for that appeal for the 2018 value, and if the decision goes against the county for the 2017 assessment, there's no reason to expect that it shouldn't apply to 2018 because all of the facts are the same, the properties are the same.
Do you understand that, Mark?
My particular interest is we keep coming around to try and send me a tax bill on models that are in my inventory, which is the case for this assessment, which is why I'm appealing. So what's going on with that, Shannon?
Okay, I'll let Shannon address that.
Hey, Mark, so last year, this park model was up along the highway by the office. It was not hooked up to utilities. It has now moved down and is set up, hooked up to utilities like all of the others. I don't think that there's a distinction in state law that exempts it from taxes if it's owned by you, and the fact that it's set up like all of the others tells me that it should be included on the tax roll equal to all of the others that are next to it.
Go ahead, Mark.
I guess where you made your mistake is it is not connected to utilities like all the others. It is being prepared for delivery, but as of your snapshot date, and frankly as of today, it is still not hooked up to utilities and has not been delivered to a customer.
It appears like it's the same as all of the others. And again, I don't think that it matters that it's owned by you as opposed to anyone else. And if it were to leave, then that is an issue that can be taken up on an abatement. It would be the same as a building that no longer exists anymore.
You
Okay,
understand?
so name to me any other dealer in Pennington County that is paying or being assessed property taxes on a park model in their inventory, please.
I don't know of any, but I don't know of any dealer that has any park model that's set up like this.
I have the right to set up that park model anywhere on my property because it's all zoned commercial and it's all part of my dealership. If I want to set it up in an RV site to advertise it for sale in the setting that it could be used in, I have that right, and it is not and should not be subject to taxation.
Thank you, Mark. I think what we're gonna do is, I think both sides have explained themselves well enough. Should we deal with this one right away, or we wanna wait and do?
Whatever you want, as long as you're aware of the Pettit one, we have a recommendation to take the shed value off.
Oh, we'll wait. I think we've got the information to make a decision on this, and I think Mark, we understand Mark's point of view at this. You understand, Mark? What I'm doing? We've heard both sides.
What are you doing?
Not specifically, no. What's going on?
Well, I think we're gonna decide on, Shannon, you have a recommendation on all four?
No change in the value except for Pettit's property assessment. We have a recommendation to remove a shed value from that. So we do have a recommendation to lower the value of that parcel by that amount, but on the other three, no change in value.
Mr. Chairman.
Mr. Busker?
Mark, this is Ron Buskerud. I think, doesn't the question, his question, revolve around the same thing that's in court right now? Whether these are vehicles, recreational vehicles, or whether they are property subject to property tax. If the court rules that these are recreational vehicles and they can be licensed to move, then I think he's absolutely right that he has a right to have, not be taxed on these, no matter where they're at or anything. But if the court rules, no, they're real property in effect on leased property, then I'm not sure it matters who owns it. It's taxed. Am I way off there?
You're correct. I want to add, though, that Courtney Claiborne has asked of Jay, and Jay has no problem with, a decision from the court on each individual of these properties, which is fine with us. So the judge could rule this one yes, that one no, and that's fine. So you're right. I agree. What you said is right. But the judge could even sort them out and say, all of them this way, or these two and those three, whatever.
Well, I'd like to be the attorney that takes that one to court.
Mr. Baskerud, you're a little bit incorrect in that the court is not going to rule whether these are RVs or not. That's established in case law, in the Rushmore Shadows case, and also in state statute. The ruling will go to intent. Intent is the key that shows whether or not these are intended to be an improvement to real estate and taxable as real property or not. As an RV dealer, I own an RV in inventory. I don't use it. I try to sell it. And for that reason, it is not taxable as an improvement to real estate because there is no intent to do anything other than sell the thing. So that's a key distinction here.
Mr. Chair,
Mr. Farabee.
And I totally agree with what Mark is saying. Now, I don't know, but I'm guessing that dealer's inventory is not taxed, is that correct?
No, that's wrong.
Taxed in the same fashion as when it's occupied and when it's used for a rental like Rushmore Shadows?
Doesn't matter how it's used.
Did you agree with that, Mark, that your inventory is taxable?
I do not.
It's not.
No. And that's the question to me, if,
Home inventory is not taxable in the state. That's specifically called out in a statute.
What-
Shandy's position is that since there is no specific statute call-out saying a park model in inventory is not taxable, well, we can probably get away with it. But I challenge you to show me, and there are at least one other dealer that sells park models in Pennington County. They're not being assessed. So what's going on here?
see, Mr. Chair, to me, that's the distinction, and that's something that separates Mark from these folks.
Let's hear Shannon address the question.
What Mark said was right. There is a statute that exempts mobile homes in the ownership of a dealer from the tax roll. There's been a lot of talk about these things not being mobile homes. And in fact, the state statute specifically says park model homes are not mobile or manufactured homes. So there is nothing that accepts these in the ownership of a dealer from the tax roll. There isn't. What does is the intent to place it on the property. And the dealer that Mr. Rutherford is referring to has some park models sitting on a paved parking lot next to the mobile homes inside a chain link fence. And there's a different intention.
Okay.
Mr. Chair, now, so you said that specifically double wides or mobiles or whatever, they're inventory tax exempt. So what about campers? On a dealer's lot, are they taxable?
There's nothing in the state law that exempts those in dealer inventory. There is a statute that specifically says mobile or manufactured homes in the ownership of a dealer. I don't know of the same for a camper.
All the RVs out there on Interstate 90, are all those taxable, those campers?
No, because they are not structures placed on the land.
So campers aren't and mobiles aren't, but these are?
Because these are structures on the land. And that's the argument we're in court over.
We're
Talking about a dealer's lot.
I think we're rehashing the same stuff.
Chairman?
Ms. Hadcock.
So Shannon, you said he's got park models somewhere else besides sitting on the land.
Not that I know of.
And he's selling this campground?
The whole campground is for sale.
Right. And Mark, this one, you said there's an owner to it and you're moving it? I thought that's what you said at the beginning.
That's correct. My intent always was to sell it just like any other. And this one, in fact, since the assessment date of November 1st, has been sold. It is yet to be delivered to the customer.
And where's that customer at by chance?
Right now, they're in California.
We have asked Mr. Rutherford if this home has sold. He has refused to provide us the owner or till this point, verify that it actually has sold. So because it's on his property, we still have it in his name.
So, and you have the name of the owner that we can verify? To know that this isn't just a home that's gonna be sold with the rest of their property when you sell the campground? Mark?
Well, let's not mix the two here. The resort is for sale, but it has not been sold, is not under contract. It has nothing to do with this particular park model sale.
Actually, it does, because if you're selling it, and you've already sold it, you have an owner, you have a name, and this is leaving, and it's not going to be taxed. If you don't have owner, and it's not leaving, then it seems to me that it should be taxed. That's my point of view. It's not inventory. It's on a lot.
Mr. Chair,
Shannon.
All of these park models have been sold by Mr. Rutherford.
I understand.
And the reason they're on the tax roll is because they have been on the property and haven't moved. They all say that they will move them, but at present, they're there, and because they're there, they're taxable.
And there's that.
Mr. Chair.
Are you done? Mr. DeSanto?
For me, the question lies within whether or not anyone has ever lived in this park model and whether or not it's hooked up to utilities as far as whether it's your inventory to sell or not. So I'm asking you, has anyone ever lived in this park model? And is it or is it not hooked up to utilities?
Mark?
The answer to both questions is no, it is not. It is partially hooked up to utilities in preparation for delivery. It is not completely hooked up. It is not livable now, nor has it ever been lived in.
Wow.
Mark, what utility, is it hooked up to an extension cord? Is it hooked up to water? What's it hooked up to?
It's hooked up to water, and there's an electrical cord that plugs into an RV pedestal just like any other RV. It is not hooked up to sewer.
And why, in order to get it prepared for delivery, why would it need to be hooked up to water?
Because of the work that has to be done underneath the unit when it's moved into place.
Wow. All
I
right.
think, Mr. Chairman,
It's
the
just-
question is, when you say deliver,
Construction timing.
deliver means that you you give the title to the gentleman.
First, right?
Delivery to you means that you give the title to the gentleman. Delivery to us means you move it off that site or off of your property. And so which is it gonna be?
That's what I'm saying.
Mark, he's asking,
Well,
is it gonna be
how do you
moved?
come up with your definition of delivery? Again, I can sell a unit from any place on my property with it still in inventory.
The truth is, you moved it down here and you're setting it up because you're gonna sell it to him on that lot.
That's correct.
Yeah.
Yeah, okay,
Yeah,
okay.
Get through to that.
That's
You
what I was
already
trying to
asked
get
me
to.
if I sold it, and the answer is yes, I have. I have the name of the buyer. I have a contract on it already. It has not been delivered.
Okay,
So are we in the habit of taxing park models that are not in use?
okay, Mark, I think the board has enough information. I think we're gonna start rolling through with what we need to do. I look for Shannon to,
Tell us what the shed is.
You want to deal with the three or the one first?
board,
The one that we're changing the assessment?
Okay, Dawn, parcel number on the Pettit one. The parcel exists of the park model home and a shed value for a total value of that parcel.
Okay, parcel ID is 66907. I have a recommendation to change the value to 38,100. It was assessed at 41,100.
So we have a shed on that property that has a value with that difference that we don't think has market value.
That'd be my motion.
Second.
moved by Hadcock, seconded by Buschard. Discussion.
Which one was that?
Hearing none, all in favor indicate by saying aye.
Aye.
Opposed? Motion carries.
Okay, so for parcels 66475, 67616, and 68346, recommend no change in value.
Be my motion.
Moved by Hadcock, seconded by Buschard. Any discussion? Seeing none, all in favor?
Whoa
I
now.
asked for Mr. Farabee.
What happens,
I'm having a little difficulty hearing.
Speaking to your mic, Mr. Farabee.
for these three folks, they're in court, or heading towards court. If they prevail, then their taxes are refunded? Or how does that work?
Shannon.
Rebate.
Yeah, I don't know if a refund is the technical term, but yes.
If the timing is such, they're obviously, they will have paid the taxes.
At least the first half, maybe, because that's the 2017 assessment that's due this year. We don't know when we'll get a decision, but, okay, so sometime this year, the 2018 assessment, taxes aren't due until next year, so if the county loses, there won't be a tax bill next year. And, yeah, whatever part was paid this year would have to be a refund.
So the 2019, if they prevail, then it'll be a refund. I mean, well, abatement, I guess.
No,
Or how will that work?
No.
No, the timing is a year off, obviously.
Yeah, the 2018, not 2019, the 2018 that's due in
Assessment,
2019.
we're working on the assessment right now for 2019
No,
payment.
2018, pay in 2019.
I just- Payment, the assessment right now is going to be paid in 2019.
That's right. So if there's a decision against the county before that tax bill is created, then there will be no tax bill.
Right.
So here's where I'm going. If we go ahead and vote in your favor, the five of us, or three of the five of us, then that assessment is added on for these folks. The assessment's added on to the total assessment for the county. But if it's taken away, then that's a tax shortage for 2019. Conversely, if the government prevails, then how would they pay if we say no to their assessment? Then how would they, procedurally, how would they pay the government?
There'd be no process.
But if the government prevails, then they'd owe taxes if we voted in their favor today.
Yes. Depending on that court decision that we still have coming up.
Yes.
we have a motion on the floor.
We do, yes,
Okay. Second, it was made by Hadcock, second by Busker
correct.
for the three properties.
Correct.
Any further discussion?
Roll call, please.
All in
Bus-
fa- all in favor, say aye in the roll call. Go ahead, Karen.
Buskerud,
Aye.
DeSanto,
Aye.
Farabee,
No.
Hadcock,
Aye.
LaCroy.
Aye.
Okay, I wanted to add one more comment. Mr. Rutherford, if he sells this home and it is still there, it would be the same as if we find out about that sale and who the buyer is, it would be the same as if any house sells. We just change the name and the address on the tax record. So as long as we're aware of the new owner, it's the same as every other property that sells. Okay, the next property this morning is Michael and Holly Bloomer. I think Michael is here. There's three properties. You're going to have to deal with each one of them one at a time. But Mr. Bloomer is here for all three, and Melissa from our office will talk about each of those three as well. You're just going to have to do one at a time.
One at a time. So Michael and Holly? One? I'll have Shannon catch you and talk to you.
What property?
Or do you need?
Just a second, and I'll be right there. What property would you like to start with?
Probably we'll start with 10404 Plantation Court.
04 Glenhaven?
How many is there? Three?
What parcel number?
Two.
10,
So, okay, so say that so they know what parcel we're looking at first.
Oh, sure. So we're gonna start with 43479, if that's all right.
43479. 10408 Glen Haven Court.
Correct.
Yes.
Okay.
Well, first of all, I don't know about you guys, but I wasn't even involved in the last one. It feels like I need a break. You got a tough one there. Anyway, my name is Michael Blumer, and first I'd like to thank you all for serving as elected officials, because I personally realize how much time it takes on your part, and sometimes it really seems like it's unappreciated time. But I do appreciate your willingness to serve. And so, and I thanks Melissa for her time as coming out and taking a look at the property and everything. I'm appealing because the assessed value on the resident portion of my property has nearly a 14% increase from last year to this year. And so I'm not appealing any of the land value or the shed value on mine, but I would like to appeal the residential portion on all three. And what I'll do, just to get you a little better informed, I did put together some information that I'd like you to take a look at. You have a little better knowledge on all three of them.
Thank you.
Thank you.
And I guess we'll start with the very first one. I'll give you a little time to look that over and read it. And then whenever you're ready, we'll
Sure.
start.
Just, I'm a
Ms.
little
Hackett.
confused. Okay, so this one doesn't have anything, Melissa, and this has 151,000. And then this one says
He's got 3 properties.
all under 43479?
No, we're just starting with the 43479. There are 3 separate individual properties that,
See? They're the same.
Written out to the side.
That's the 10404.
That's why I'd not,
That one's got nothing.
that's what I'm saying.
correct?
And they're the same numbers.
10404.
I told him 104.
Okay, let's start with this one.
They're the three on that packet.
Uh,
See what I'm saying?
Oh, I'm sorry.
Do you?
I didn't get
If
the
it's the
copy of
same,
this.
I still have. Is it different?
No,
There's
it
3
is.
Yeah, I see.
Revised some things.
What she's, what Ms. Hadcock's talking about is the next one underneath it. 3609253-006 has the same number, 43479.
It doesn't have anything on the bottom, what land or anything else on it.
But it's got up here residential 72.
Was that from our office or was that from?
His name on that.
Yeah.
Melissa, I don't know, but you have 3 appeals and you have only have one take. Melissa, will you look at them?
Can I look at them? Is that?
Yes, ma'am. Thank you, Miss Melissa. There's 3 appeals and those are the only 2 papers we have. Am I confused?
Oh, are these townhouses?
Yeah, there are
Okay,
3 connected townhomes.
three connect, yeah.
I believe this was something that he had filled out on his own.
And this is what we're doing now.
Official copy, I believe.
Okay, and so where's the other 2 appeals?
Thomas Mine and
Is it Judith? Okay, that's why, because it doesn't have the same. So Judith, Kreutz, Judith, and then the next one? Oh.
He's representing. Okay.
Oh,
So,
all
okay,
3.
okay, I
Okay.
see what you're, there, thank you, Miss Judith, or Judith, Miss Melissa. Okay, everybody got that? So the next ones are Judith Arkavides and Thomas Hine. They're the ones right after this one.
I would like to start with the one with the Thomas Hine first, please.
Thomas Hine, okay.
Last one.
You want to do Thomas Hine, sir? Okay,
Okay, we have that one in front of us, I think. Has everybody got it? Towards the end.
keep going, George, it's further in there.
Okay, everybody's got the Thomas Hines.
Okay, and that's the first one after the explanation of all 3 properties of the description that I handed out to you. It's the first one at the 10404 Glenhaven Court.
That's the first one.
And that would be under Tom Hine.
Yes, sir.
Okay? And you were able to read the first description of all three of them, how they're built in 1985, so they're 33 years old. They all have 33-year-old siding, 33-year-old decks, 33-year-old garage doors, windows, 33-year-old cabinets, and 33-year-old single bathrooms. So they have not been updated hardly at all. Mine had been updated, but on this one here, this was sold to Tom Hine March 30th of 2018, and the sales price was $104,000. And so it was sold through a real estate agent, advertised on MLS, Zillow, and Trulia. There was only one offer on it, and it was an arm's length transaction. So the real estate agency, it would have been his fiduciary obligation to tell the sellers that it was too low of a price if they thought it was. And then not only that, but they weren't in a hurry to sell it because they did have it it was a relative of theirs that passed, and they had it for 9 months before they even put it on the market. So they paid utilities and taxes and insurance on it for 9 months. So as I've kind of explained in the first portion there of it. And so I guess what I'm asking is that the assessed value on this, or true market value, be placed at the $104,000 that it was sold for. And I realize that it might have been sold after the November 1 date, but I couldn't find anything in South Dakota codified laws stating that there was a date when there was an appeal that the actual sale price of a piece of property wouldn't be valuable information and could be used as to appeal the assessed value on it. And so that's what I'm asking, or Tom Hine is asking through me, that the assessed value be set exactly at the sale price of $104,000.
Okay, thanks, Michael. Melissa?
Sure. So the property is located at 10404 Glenhaven Court. I'm recommending no change to the 2018 assessed value of $112,600. And that's $40,000 on the land, $72,600 on the building. So I just want to address a couple things that were said. The property sold in March of 2018. The certificate of real estate value does say $105,000. So let's see. I think I included on there too that, this property was only listed on the market for 49 days. Mr. Bloomer shared the purchase agreement with me, and it does say that this was an estate sale. It was a cash sale. There was no property inspection, no appraisal done either. So it is my opinion that this is under market value. So this is a end unit townhome built in 1985. The home is original, no updating, and it is showing signs of some deferred maintenance. It's 2 bedrooms and 1 bathroom with no basement and an attached garage. There are 4 comparables up there on the screen for you. Sale number 1 was built the same year as the subject, and all of the other sales are actually older than the subject property. All 3 are similar in overall square footage. 2 of them have 3 bedrooms, the other 2 have 2 bedrooms. They all have only 1 bathroom, just as the subject property. None of the comparable sales have basements, just as the subject property. Sales 1 and 4 have attached garages. Sale 2 has a detached garage, and sale 3 has no garage. And you will notice by the sale prices there that all of them sold for more than the assessed value of this property. So again, my recommendation would be no change to the 2018 assessment of $112,600.
I would like to add that when Dick Maresca was employed as a CCA and came out and reviewed it 3 years ago, as noted on the sheet that I gave you, that Dick said that, in parentheses here, this is unique property. It is in a 55 subdivision and a 3-unit townhome. I don't know of any comparable parcels in Pennington County. And because they're unique, I don't believe that the mass appraisal system should be used, nor do I believe that any other types of properties should be used as comps. But I do have the three that are adjoined to each other, and I believe they are really the only comps that should be used, and that is the sale price of these pieces of property, because it is unique, stated by a previous CCA that worked for the county. And I'll also hand these out if you do think that comps are necessary that are not one of these three.
So you said these properties sold, how many properties sold in this in this?
I went on to Zillow and looked at all the properties that were townhome condos for sale that were recent.
No, in your area.
I'm sorry?
You said there's one that was sold for 104,000.
Yeah, that's one of the three that I'm appealing.
And then there's any others in that area that have been selling?
No, there's no other tri-homes, or I should say, townhomes like this in all of Pennington County.
Yes, there is.
Because, what's that?
Yes, there is.
Okay, could you tell me another rural
It's on,
55 and older community?
well, now you're adding rural. There
Yeah.
is a threeplex on Minnesota Street that my wife owned before we moved in. It's,
Uh-huh. But that's not rural, and it's not in a 55 and older community, am I correct?
no,
Okay.
but it's a
And so
three.
that's part of the reason I don't think that that could even be a comp.
Okay, I guess I'm getting back to my question. So you sold, one got sold in your townhome area, and it was for 104. Was it 2-bedroom, 3-bedroom?
It was a two-bedroom, single bath. That's the description of the very first one, 104 Glenhaven Court.
Yep.
Mm-hmm.
And no others have been sold in that district?
We're the only three. See, the original plan was that the whole cul-de-sac that we live in was going to be all townhomes. But because of a lack of interest in any of them, these three were the only three that were sold. And out of the 40 plus or minus homes that are out there, we're the only three townhomes out there. All the others are single residents. And so that's why I don't believe that even things that were sold in our 55 and older community, because they are all single-family residences. Some of them, most of them are stick-built. Some of them are manufactured. But they're a totally different type of structure than a townhome condo.
Mr. Chair, if I.
Melissa,
So I did want to address what he was saying about the 55 and over area, if that's okay. So it's the Evergreen Valley subdivision, as he said, there's 40-some properties up there. So I did look at all of the sales that had happened in that area. And when I take a median ratio for the last 3 years of valid sales, I'm coming up with 91%. So well below the 100% of market value, showing that our office is not overassessed in this area, and that the 55 and over is not adversely affecting the value. So I just wanted to address that too, that when we look at the numbers and we look at the medians at the sales ratios, we are low in this area. It appears to be more desirable because of this.
I'll go to the board for some discussion.
Mr. Chair,
Mr. DeSanto.
Again, I'd like to state
Just a
that-
second, we got Mr. DeSanto.
I believe that Melissa has done her homework quite well on this piece of property. I also agree that if it was sold and known to the public that it was on a estate sale type of situation, it's not going to bring the value that it's actually worth. Very, very seldomly, unless it's a really, really special piece of property, will an estate sale bring a higher value than what the house is actually worth. And so, and like I said, I feel that especially with her saying the last comments that she made, that she researched whether or not, because it's a 55-year-old and older community, that it has an adverse effect on the prices of the homes there. And she's done her homework and said, no, it doesn't have an adverse effect. It actually makes it more desirable.
Mr. Chairman,
Mr. Buskard.
going along with Mr. DeSanto, since I live in a 55 and older community, according to some of George's friends, over half a year, which really is not the truth, but living in a 55 and looking at prices in a 55-plus community, it's not adverse. It is a plus.
Yeah.
You get more money for that. Because there are some of us who have raised our kids and don't want to raise our neighbors.
Feel some love down there.
Commissioners?
I'm not advocating that the 55 and older community devalues property values, but what I am saying is that the comps in our 55 and older community shouldn't be eligible comps because they are single-family residences, and we are the only 3 townhomes in that 55 and older community. And when it comes to townhome condos, if you take a look at the second sheet that I handed out, you can see that from sales that I looked up on Zillow.com, that almost half of them sold for less dollars than they did on the previous sale. And so townhouse condos don't necessarily appreciate in value, especially like single home dwellings do.
Thanks, Mike.
Chair.
I'll go to Adcock first. You hadn't spoken.
Glen Haven Court at.
It's located in High Sega, but I would like to clarify that these 4 comparable sales are townhomes. They are not single-family homes. These are townhomes.
But they are not out in the country, and they're not in a 55 and older community. They're in town,
Okay, we've got that.
okay?
We got
You
that.
must have gotten hers too then.
Any follow-up?
I'm good.
Sir?
Sorry.
Melissa, go ahead.
So he was just discussing, townhomes decreasing in value, so I did just want to also say that I did a paired sales analysis of 13 pairs of sales, so 13 different sales that had happened in townhomes throughout the county, and just came up with an appreciation rate of 9% per year, as opposed to, the 3% per year that we were kind of seeing overall in the county. So to me, it's appearing that townhomes might actually be appreciating at a faster rate than other properties.
Mr. DeSanto.
I live in a townhome. It's three townhomes side by side. The 2 next to me just sold. They're all identical to one another. And in 2 years, they increased in value by $27,000 each, which is approximately 13%. And so I think that she's correct. I think townhomes are actually starting to be a positive. They're increasing in value. And I am in a rural area.
But I'm showing you the sale of
Yeah,
an actual sale here too.
yeah.
Motion.
I think,
It is an actual sale. You can't find better comparables than your next door neighbor
yeah.
in a townhome.
Okay, Michael, I think we've heard the arguments on both sides. I think I'd look for a motion on this.
I would move to approve at the assessed value.
Second.
No change.
Moved by DeSanto, seconded by Hadcock. Keep the assessment as set. Further discussion? Seeing none, all in favor indicate by saying aye.
Aye.
Aye. Opposed?
Aye.
1 no from Farabee. Next one,
43479, is that okay, or do you want to do the one in the middle?
10408, or 10406, please.
Oh, okay, sorry. Yeah.
10406. And the name on that one is?
Judith.
Arvidas.
Okay, Mike, these are the same ones, correct? Michael, in the same 3?
Yeah.
Okay.
This is the interior unit.
The middle one?
Yeah.
Oh, okay.
So it has a single garage instead of a double garage, and then, of course, no sidewalls. And so if you want to look at the description that I gave you on the first page there,
Can you bring that picture up bigger, please? Okay, so that,
there again, that one is very similar to the first one that we talked about. Neither one of them have ever had their decks stained in 33 years, front or rear. Garage doors have never been painted. The exterior has never ever been restained. It's never been painted. There are woodpecker holes in all the cedar siding. You can see the asphalt, how it is totally deteriorated. They're all original windows. They just have no updates whatsoever.
Melissa, you did a site visit, right?
Correct. So we did interior and exterior inspections on the 2 outside units. We weren't able to get into the interior unit, but I was in it a few years ago, and nothing has changed since I was in it a few years ago.
Chairman,
Ms. Hadcock.
your land is 40,000 and the structure is 66.4. I think that's pretty fair. So I'm gonna, recommend and make the motion no change.
Motion's been made,
Second.
seconded by Busker. Any further discussion? All in favor indicate by saying aye.
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 Opposed?
Aye.
1 no from Mr. Farabee. Okay, so now we're going to,
Last one. 43479.
Judith's.
Nope, we just did
That's what
yours
we just did. So 43479 is the tax ID of the final one.
when we started. Michael.
Oh, okay.
Judas.
Michael's right
There
here.
you go.
Okay.
On that one, you can see that 10 years ago, there was a 120 square foot addition to that. So this one is a little bit larger by 120 square foot. This is my personal one. And it's the reverse of the first one we talked about in floor plan, but identical floor plan other than that. And so when we bought it in 2013, we paid $112,000 for it. And there again, it was on the open market. It had been advertised for 6 months by 2 different real estate agents. It's an arm's length transaction like the other one was. So that's why I feel this one too was a market value. Like I believe the first one, sale price should have been market value. They put $20,000 into it, more than $20,000 into it before we bought it for $112,000, and 7 years previous to that, without the $20,000 addition, it brought $12,000. So it's brought the same price 6 years later, after $20,000 worth of additions. And so I just want to point that out, that I'm not contesting the land value, and I'm not contesting the $20,500 that Melissa assessed the shop at. But when you break down the resident portion of it, it's almost a 14% increase from last year to this year's assessment, and I think that's very excessive.
Melissa.
Sure. So 2018 assessed value of $153,500. I am recommending a change in value on this one to $151,000. It's a land value of $40,000, building value of $111,000. So that value recommendation change is just due to some data corrections made on site after our visit. We had a couple measurements wrong, changed the classification of the shop building as he stated. So yeah, this is again an end unit townhome built in 1985. This home has had some updating and some, better maintenance over the years than the other properties. And then I would just like to address the previous sales that he was saying that happened on the property. So you guys know too, our office uses 3 years of valid sales. Both of these sales are outside of that time frame, and the shop building has been built on the property since Mr. Bloomer purchased it also. So it's had a pretty major physical change since the time of the sale.
The board have any questions?
Yes, sir.
I would like to add that I'm not appealing the land value, and I'm not appealing the building value or the shop value. But I would like to appeal the residential value that went up almost 14% from last year to this year, which is, I believe it's a $10,500 increase
Okay, Mike,
on year,
Did you
on the
see-
residents only.
did you see that she readjusted it from the original one?
She did not readjust the residents that I am appealing.
Okay.
She did adjust the shop, but I'm not appealing what she adjusted the shop.
Okay.
Miss Melissa? Sorry. I
Sad
didn't
guy.
mean to- Okay, so his residence is, the land is 40.
Yes.
You had the shop at what?
20,500.
The shop is how big?
1,400 square feet.
Okay. And that was how much again? 40?
20,500.
20? Okay. As big as my house.
I think so. I was trying to find.
And then the land is the rest.
40,000.
40.
Oh, I'm sorry, land is 40, sorry. Shop is 20, and house is how much a residence? The difference I understand, but I didn't figure that.
90,
93.
yeah, 90,500.
Okay. And you're appealing the residence?
Correct. That would be a almost 14% increase. And actually, since I've moved there in 5 years, that ends up being over a 23% increase in the last 5 years of the residents. And I think that's excessive too in a 5-year period.
Okay.
So, and I would point out with my recommended changes, the percent increase would be 5.8. So
So I-
5.8 would be the overall increase
Right,
with the
overall, but I'm
recommended.
not
With
contesting
your
the land.
adjustments, it'd end up being a 5.8. Melissa's new adjustments is 151 even, 151,000. That's 40,000 for land and 111 for structures, which is including that shop.
Right.
So,
I'd like to also mention that when she said there's been upgrades to mine, the upgrades were part of the $20,000 upgrades that previous to me buying it.
yes, that's upgrades compared to the other two units.
Chairman?
Mrs. Hadcock.
I think the land is good, I think the shop at 20 is good. The other two residents are 66 and 72, and his is 93.
Is a little bigger, I think, too, isn't it?
It's bigger and it's in much better shape. Like he said, the decks had not been maintained on the other ones, the siding not maintained on the other ones. His is definitely in much better condition than the other two.
When you figure value, you have to realize the value of paint. It looks cosmetically a lot nicer, but it's still a 33-year-old deck. I would really appreciate it if you'd bring my residential a little bit closer in line to what the other ones are. Especially since all the upgrades were done before I bought it 5 years ago.
It's got a shop on it. I'll speak out loud. I don't want to be doing sidebars here. In my feelings, I think, the shop adds value and I mean, you said yourself that yours is better maintained than these other ones in square footages. So, and seeing some of the prices that I have in the properties, I don't think it's that far out of line. I think Melissa did a good job of coming back and she's even reduced it down to a 5%, taking a lot of stuff in consideration. So I am okay with the 151 with the adjustments that Melissa had made from the original 153. I'd look for the board ready, what their
153.
thoughts are.
Basically, what you're saying is that my residential, not the land, not the shop, but because my residential is worth $12,000 more than the first one, and even more than that on the second one we talked about. And because it's got a little bit more paint on the decks, that I did paint the deck. But other than that, all the improvements were done previous to me buying it. And so that, I would appreciate a little reduction in the residential portion of mine, because the first one, it's $12,000 less than mine, and the second one is even way more than that, less than mine.
Okay, Mike.
Chairman,
Mrs. Hadcock.
I have a recommendation. So we got 40, 20, and then 86 on his property or his residence at 146 is my recommendation.
You're making a recommendation of 146, even in what you're taking that is off of is the structure.
Yes,
Is there,
land. So it's 40, 20, and 86, which is 146. That gives him somewhat of a reduction. His improvements were done before, and it was still the same assessment. And now, the other ones are 66 and 72. I understand they're in less shape, but I don't think that's a,
so we have a motion.
yes, sir. Sorry.
I'll second.
Motion for 146 with the reduction coming off of the structure. And there was a second by DeSanto. Further discussion from the board. Seeing none, all in favor indicate by saying aye.
Aye.
Opposed?
Aye.
No. Motion passes. Did you say no, George? I
I
couldn't.
said aye.
Okay, three ayes and two noes. The two noes from LaCroix and Busker. Motion passes.
Thank you very much. Could you break down that for me again, please? The 40,000 on the land,
20 for the shop,
20 the shop,
86 for the residence, sir.
6 residents.
Yes, sir.
Okay. Thank you very much for your time. I sure appreciate it.
Thank you, sir.
Mr. Chair,
Mr. DeSanto.
I'd like to thank Melissa for that. That was a tough one, I think. And I'm familiar with the area up there, and there aren't a whole lot of comparables, you're right, but I think you did your due diligence and study on that. I appreciate it.
Shannon.
Okay, next on the schedule says a mobile home list. That's some cleanup that we do every year, but I'd suggest you go to the exempt properties and get a whole bunch of people here for that, and we can deal with that mobile home list after they're done, and deal with the exempt stuff while they're here.
I'm gonna do that right after we take a 5-minute break.
Yep.
He's in ears length, so we'll get started.
Okay, so what was postponed or whatever until today are the list of properties that's titled with denied exempt. That was just my recommendation to the board to deny the exemption because we did not have an application by the November 1st deadline that's set out in state statute. And so what the statute says is the application is required annually, and if an organization misses that application, it prompts a review by my office as if it's the first time. Should the property be exempt? Do they qualify? So as I stated before, all of these properties, except the very top line, we dealt with Westminster Presbyterian Church, different property, doesn't qualify for exemption. We talked about that last time. You already acted on that. All of these others, they, with the exception of missing the deadline, would otherwise qualify for the exemption, and I would recommend that you make them exempt from property taxes. Now, I think most of those organizations have somebody here. I'm not sure about Box Elder Economic Development, but I've talked to everybody else on that list, and they all came here because we sent them a letter. But my recommendation is that they be exempt from property taxes.
That'd be my motion.
Second.
Motion made by Hadcock, seconded by DeSanto. Mr. Busker for comment.
I see you have Lakota Community Homes on there. Is that, you're gonna exempt every house up there?
No, that's not on.
It's on
Oh,
my list.
okay, you put that on a new list. I would like to deal with that one separately, and I was saving my notes. No, there's a commercial building out there that they have a daycare in, so I want to deal with that one separately.
So,
Amend your
motion
motion.
maker, are you okay with removing Lakota Homes? And second, are you okay?
I'm okay with it.
So minus Lakota Homes.
I apologize, yes.
Any further follow-up from the commission? Seeing none, all in favor indicate by saying aye.
Aye.
Opposed? Motion carries unanimously. Now we're to,
Okay, so I'd like to talk about a few specific exempt properties, but for the audience here, the Boy Scouts, Girl Scouts, Lighthouse, all of that, they're done, just so everybody there is aware of that.
Thanks for coming, though.
thank you.
Think about it next year.
Okay, Lakota Community Homes, yes, Deb did add that to a list that she gave you. Lakota Community Homes, not the property we're gonna argue about the value coming up, but they have a commercial building. It is parcel 47597. They rent it out for a daycare. Lakota Community Homes, as an organization, doesn't qualify as a benevolent organization exempt from property taxes. They have been in the past. It shouldn't have been. I'm recommending that we make it taxable with a value of $224,500. I've talked to their attorney. At least the property owner is happy with it. I'm not sure about the attorney, but he's not going to argue anyways. So my recommendation is to make that taxable at $224,500.
That would be my motion.
Second.
There's been a motion and a second discussion. Shannon, what was it before, you said?
It had been exempt for at least several years, and it should not have been.
I'm not in agreement with the motion, but
Miss-
any further comments, Mr.?
Just to refresh, when we talked about this previously, this is building primarily for daycare.
Say that again.
Primary.
This building is being used primarily for daycare?
Yes, they also hold their board meetings in it, but a daycare in it every day.
Well, as I said before, and I'll repeat if I can, if I may, all these adult daycare centers are exempt. Looks like the kiddie daycare should be exempt.
Okay,
Thank you.
further discussion? Seeing none, all in favor indicate by saying aye.
Aye.
All opposed? No.
Aye.
So we got 2 noes from LaCroix and Farabee. Motion passes.
Okay, so that one, I have another exempt one I would like you to take up. The Retired Enlisted Association. You've actually already acted on this, I think, approved because it was a partial exempt. But I spent some time with Mr. Martinez with the Retired Enlisted Association. He took some information to their board and come back with gobs of activities that he says they use that property for. And I would like to recommend a different percent exempt based on more stuff that I know that they're doing now. The property was 20% exempt from taxes. I'd like to recommend that the TRIA property, I don't have a parcel number.
Okay.
We'll have to find that, but it be 33% exempt.
From 20 to 33.
Correct.
Is there a motion?
So moved.
Second.
Moved by Farabee, seconded by Hadcock. Discussion? Hearing none, all in favor indicate by saying aye.
Aye.
Opposed? Motion carries unanimously.
Okay, so that's the exempt. Next on the list is LN Real Estate Furniture Row. We heard over the phone, and we've received written notice that they have withdrawn the appeal. So we have no appeal on that. It doesn't require action. We have written notice that they want to withdraw, so it's a non-issue.
Okay.
let's go to Lakota Homes.
Great, that's why I like to move along. I like to do that.
At will, still at will. They're ready.
On my side of that.
Well, excuse me.
I'm just not in my right mind over there.
Okay.
Neither is he, so you
I
guys will
must
get
not have
along.
kept my paper.
Okay,
Did I say that, Shannon?
Lakota Community Homes, this was postponed or whatever till today. I made a very eloquent argument about how its property should be assessed at $12,621,000, and now I need to recant. I would like to recommend that the board leave the value at the Rapid City Board did at $11,440,750.
That'd be my motion.
Wait. Is there an agreement?
Yes.
Thought he was smiling.
That's deceiving, he's a lawyer.
Whoa, you're not getting some love here,
A little
son.
comic relief this morning. Never.
Okay, so there is a motion, you're okay with 11, what was it again, 11?
447.50.
447.50.
Okay,
440,
$11,440,750.
okay, so there's been a motion, is there a second?
Deb, hold it, I just thought, 750? 700,000? Our computer rounds to the nearest hundred. For Lakota Community Homes, how can we have, that was my total. I totaled up all of those parcels, there might be a rounding error. Because our computer rounds to the nearest hundred, that gives us fits. Let me say that I recommend that the value be the same as what the Rapid City Local Board did, which is very close to that number.
11 million something.
Yeah.
Okay.
750.
So Hadcock moved,
It would be that because I forced those values in,
Okay,
so it would be the 11,447.50.
okay, all right.
okay,
11,447.50.
okay. That's
Many
Ms.
times that, that last number there gives us fits when we try to put it in.
Okay, so that's Ms. Hadcock's motion. Is there a second before I move? And this is an agreeable one.
Mr. Chairman,
Mr. Buskard.
now I know what happened to $1,200,000.
Okay. I made a mistake. The property owners hired an appraiser to appraise the property. Comes in a lot less. I don't agree with the appraisal, and I'm happy to argue that. But in checking his math, I found an error in mine. And if this appeal were carried to a next level, I don't think I could defend that value. And it all revolves around an income approach to value on this property. And as we've progressed on this, I have become more convinced that an income approach is applicable to this property. I still think a cost approach and a sales comparison approach are still applicable as well. I just don't think I could defend the 12 million value that I was recommending before.
Do you want that out of your salary or the whole office's?
The whole office.
That's good.
Mr. Farabee, did you have a comment?
Yeah, I do.
I know,
Yeah, we probably should have got the second first and then,
yeah,
well, since
we'll do the motion.
I gotta ask, how did Rapid do this, local board? Was it?
I
did
can't
they
think of a
pull
polite way
numbers
to
out of the
say
air, or
that.
did they have?
Pulled it out of the air.
Well,
No, actually, the
No.
property owner had a value and they went with that.
There you go.
But
It's based on our submitted values,
Yeah.
which were based on an income analysis, not the appraised value, but it was an income analysis.
okay, so they did have some reason other than this.
Right.
Thank you.
That we,
Okay, Ms. Hadcock, your motion?
Same. 11,447.50.
We didn't have a second yet.
No.
Is there a second?
Second.
Seconded by Buskard. For discussion, seeing none, all in favor indicate by saying aye.
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 Opposed? Motion carries unanimously.
Thank you. You need anything else from us? or-
Nope, hope I never see you again.
Must have done a fine job.
It's good to see some humor in this. So we're done with the exempts. Now we're on to the mobile homes.
Yes, we're clean up here at this point.
Oh, we got a couple more that you need to clean up before the mobile homes, don't you?
That mobile home list that you have, every year I try to explain this, and I wind up going to Deb anyways. Deb, what is this?
These are mobile homes that have been pre-registered. So they've paid their taxes in advance, so what we want to do is remove them from the tax rolls, because they've already paid their tax in
They've
advance.
transferred title or moved, and then they're required to pay taxes, and so now we don't want to duplicate next January a tax bill.
Saves you from doing a bunch of abatements.
Yeah, because we know about them at this point. Otherwise, we do abatements from now on, but we know about these right now. Let's deal with all of them right now.
Make a motion to approve the pre-registered 2018 manufactured homes list.
Second?
Moved and seconded. Any discussion? Seeing none, all in favor indicate by saying aye. Aye. Opposed? Motion carries unanimously.
Okay, I have two other things for you. Yesterday, you heard the wall appeals, and you acted on a list there that included two properties with no change in value. By the time that list was printed, these two properties were included there, and then Joe was in contact with the property owner, and he does actually have a recommendation to change the value on these two, but we didn't get them. It was too late. You already had your list. And we didn't bring this up yesterday. We'd like to bring these two parcels up and deal with these two with a recommendation to change.
Okay, thanks, Shannon. Joe?
The first parcel is 7256, which is owned by Wall Drug Store. It's one of their residences. We had the assessed value at $77,100, and I'm recommending $71,100. The land would be at $13,300, and the structure would be at $57,800.
Be my motion.
Moved and seconded. Buskard? Discussion? Seeing none, all in favor indicate by saying aye. Aye. Opposed? Motion carries unanimously.
The next property is 18951. It's owned by Jerry and Kimberly Morgan from Wall, and we had an assessed value of $131,600. As Shannon said, I spoke to them in the 9th hour and was able to make some adjustments to the property based on our conversation, and I'm recommending a value of $126,100. The land will be at $14,300, and the structure should be at $111,800 or $126,100.
Mr. DeSanto.
What property was this that can you describe it?
208 Norris is the address. It is right across from the grain elevators. It'd be to the east of the elevators. It's the second to the last house on Norris before.
By the campground.
On the other side of the elevators from the campground.
Gotcha.
And it's on the TV screen.
It's that one.
All right. Move for approval.
Moved by DeSanto.
Second.
Seconded by Buskard. Discussion? Seeing none, all in favor indicate by saying aye. Aye. Opposed? Motion carries.
That's it.
A motion to adjourn the 2018 Board of Equalization.
Been moved to adjourn. Second. Second by DeSanto. All in favor indicate by saying aye.
Aye.
Opposed? Motion carries. We're adjourned.